All right, as we continue to wait, just so everyone knows, we are streaming on YouTube.
Hey, Judge Henry, I need to move one of our jurors.
Okay.
Juror Liss, can you hear me? Harry?
Yeah. Yes.
Would you mind just logging off of this Zoom meeting and going into courtroom 8?
No problem.
Thank you so much.
So it looks like we still have a number of courtrooms that are waiting for jurors. So I'm going to turn my video feed. Actually, I'm going to leave the video feed off. I'm going to leave myself muted and go grab something to drink and then be back. Hopefully by then we will be ready to start because you all look like you are anxious to go ahead and get this thing going. So as soon as we are able to, we will get it going. All right, everybody. Good news. We have all of the participants here, and we have just gotten the message to get started. So we will call the case of State of West Carolina v. Timothy Ray. My name is Judge John Henry. Scoring judges, will you please confirm that your audio and video are both off? They should remain off until the trial concludes. Looks like that's been done. I'm also going to ask our scoring judges to make sure that they are set to hide all non-video participants. So the only people that are on the screen right now should be the 4 advocates and me. All right. Right. Ms. Padilla has indicated that that she's seeing things the way that she should. Can I get our other 2 jurors to Juror Weingarten and Juror Finkelstein? Will you 2 confirm that audio and video are off and you are only seeing the 4 advocates and me, correct? All right, excellent. So now that we've gotten that out of the way, counsel, will you please state your appearances?
Good morning, Your Honor, or good afternoon, Your Honor. Sandra Gavazzi, and along with my co-counsel, Paloma Yanez, we represent the defendant in this case, Mr. Timothy Ray. Would Your Honor like a statement of the case at this time?
Hang on. Your last name is pronounced Gavazzi?
Yes, sir.
Okay. No, let's let the remaining counsel state their appearances before we get into the statement of the case.
Good afternoon, Your Honor. Adrian Ward for the state.
Good afternoon, Your Honor. Victoria Pescolo for the state.
All right, and I did not hear the second counsel for the defense state their appearance.
Good afternoon, Your Honor. Paloma Yanez for the defense.
All right, excellent. All right, now, does either party have any pretrial motions or any other preliminary matters you wish to take up?
Yes, Your Honor. Defense has 3 motions in limine.
All right, let's go ahead and hear those.
Your Honor, pursuant to Federal Rule of Evidence 704B, the defense moves to bar the last opinion of the state's expert witness, Dr. Mac LaGreca, as this opinion opines on the ultimate issue in this matter. Your Honor, turning to page 75 of the record under subsection C, even if Timothy Ray suffered from schizophrenia and was not malingering during his clinical interview with Major Riley, Timothy Ray understood right from wrong on October 17th, 2018. Your Honor, once again, understanding right from wrong goes directly to the ultimate issue in this matter.
Do the people wish to be heard? Does the prosecution wish to be heard?
Yes, Your Honor. The prosecution will not be eliciting that statement from the expert witness at trial. We know that that would be a violation of the local rule and the precedent of Pascarella v. West Carolina.
All right, that motion will be granted. What's the defense's next motion?
Your Honor, pursuant Federal Rule of Evidence 701, defense moves to bar Detective Booth from making any testimony about Mr. Ray's mental health or his mental stability at that time. Would Your Honor like some background?
I'd like a little bit more information about your motion.
Of course, Your Honor.
Specifically, are you wishing to exclude?
So we have reason to believe that the prosecution will ask Detective Booth to opine about whether or not my client had a mental health issue or whether or not my client was mentally stable at the time of his encounters. However, Detective Booth is admittedly not an expert witness in the field of mental health or any type of medical expert. So we're just looking to bar any and all opinions related.
Okay. What does the state have to say about this?
Your Honor, we do not intend to have Detective Booth testify to his opinion as if he was an expert. We intend to have him testify to his observations that he made.
All right, that seems reasonable to me. Defense, do you have any issue with that?
No, Your Honor, so long as the prosecution is looking to introduce facts underlying his opinion, that's acceptable. However, we will still look to bar any opinion, as we have two expert witnesses in this case who can testify to that.
Right, and I think what counsel is saying is they don't plan on eliciting any opinion from Detective Booth. So, to the extent that you're concerned about that, I think, take counsel at her representation that they don't plan on eliciting any opinions, and they do plan on eliciting facts from Detective Booth about what he observed, which I think are clearly admissible.
Yes, Your Honor.
So with that understanding, that motion will be granted. And what is the defense's third motion?
Your Honor, defense looks to bar the introduction of Exhibit 10 on page 57 of the record. These are screenshots of Google searches. Would you like me to provide some background again, Your Honor?
Yes, please. Tell me more about why you're moving to exclude these.
Of course, we have reason to believe that the prosecution will look to allege that these Google searches were made by Mr. Ray. However, they will be unable to provide sufficient foundation for this piece of evidence. First, they won't be able to prove that this was in fact Mr. Ray's phone. Second, whether or not it was Mr. Ray's phone, they won't be able to prove that he was the one who did in fact make these Google searches. And last, Your Honor, they will not be able to provide a chain of custody from when the phone was recovered until when a forensic examination was run on the phone.
Okay, what does the prosecution have to say?
Your Honor, the parties stipulated before trial that all of the exhibits were obtained constitutionally and that they are all authentic. Moreover, they survived a motion to suppress pre-trial.
Okay, I understand that that deals with all constitutional issues, and the stipulation deals with the issue of authenticity. So I think that probably takes care of the issue that it's his phone. But what about counsel's argument that you don't have any evidence to show that it was his search? What evidence is there regarding that?
I mean, the state will elicit through the testimony of Detective Booth that the phone was recovered is his, and there was a forensic investigation on that phone.
Okay, but again, that deals with proving that it's his phone. What about the fact that he was the person that conducted those searches?
Your Honor, it's stipulated to Stipulation 9.
I think there may be some disagreement there because I see Ms. Gavisi shaking her head no.
Your Honor, although there was a stipulation that these searches were found constitutionally, there was still an availability for objection, which we are raising at this time. And again, we stand on our objection.
All right. Mr. Ward, can you read me the stipulation specifically?
Yes, Your Honor. The forensic analysis of Timothy Ray's phone was conducted on October 22, 2018. Sorry, Your Honor, this is page 5, Stipulation 9, by the way.
Okay, thank you.
It showed that on October 18, 2018, 3 Google searches occurred as reflected in Exhibit 10. There was no forensic data available to determine at what time the searches occurred.
Okay, so I think that, like I said, it takes care of the fact that it's his phone. I don't think that it deals with the issue of his search, or that I don't think it helps us at all to prove that he was the person that conducted the search. Nor do I think that the stipulation deals with the chain of custody, which I think the chain of custody is only important to the extent that it helps us determine that Mr. Ray was the person that conducted those searches. So I'll give you one last opportunity to respond to that issue directly, that issue being how are you going to shore up the fact that these were searches that were conducted by Mr. Ray as opposed to searches that were conducted by someone else?
Your Honor, that's an issue of fact. The stipulation says it's Timothy Ray's phone, and the defense is welcome to cross-examine Detective Booth on this issue.
Okay, I'm going to allow the evidence in. I think Mr. Ward kind of hinted at it, but ultimately I do think that circumstantially, there is potentially enough evidence from which a reasonable juror could conclude that Mr. Ray was the person that conducted the search. The issues that you're raising, Ms. Gavizzi, I certainly understand them and agree that they are issues, but I think they ultimately go to the weight that the jury may decide to give to the evidence as opposed to the admissibility of the evidence. So I'm going to deny that motion. And I believe those are the only motions that the defense has. Is that correct?
Yes, Your Honor. No further motions in limine from the defense.
All right. Does the prosecution have any motions?
Yes, Your Honor. Before those motions, there are a number of housekeeping matters the state would like to bring before the court.
I'd rather deal with the motions first, if you don't mind.
Yes, Your Honor. Your Honor, by way of background, this is a murder case that involves the death of a child at the hands of his father, this defendant. Defendant has given notice that he will be asserting an insanity defense. Now, the defense psychiatry expert's report reprints a direct quote from the defendant that includes a reference to expressing fear that, quote, he knew he was going to jail for what he did. The state wants to put the defense on notice that we will be eliciting this statement at trial as an offer of proof that the defendant was malingering or faking symptoms of insanity for his defense. We anticipate that both experts testify that when a defendant is facing jail time, they are much more likely to malinger.
Okay. They're on notice. Do you have any other motions? Do you have any other motions?
We do.
Yes, Your Honor. Your Honor, the state moves to preclude any opinions given by Officer Wentz about the defendant's mental health based on when he spoke to the defendant. As Mr. Ward just said, by way of background, this is a murder case that involves the death of a child at the hands of his father. And Officer Wentz was the first officer who interacted with the defendant, and we anticipate that Officer Wentz will testify as to what he thought the defendant's mental state was at the time. Therefore, we move to preclude Officer Wentz's testimony that he thought the defendant was having delusions and in a bout of insanity. Under 701C, a lay witness is precluded from testifying to anything based on scientific, technical, or otherwise specialized knowledge within the scope of 702. This would require expert testimony, and the defendant is able to present an expert to testify as to what he or she thought the defendant was experiencing at the time.
All right, defense, do you wish to be heard?
Yes, Your Honor. Officer Wentz's testimony is not an improper lay opinion. He will be testifying based upon what he rationally perceived and observed when he was interacting with the defendant on October 19th. Additionally, his testimony is circumstantial evidence of the defendant's state of mind. However, Officer Wentz will not be using scientific or medical terms to determine the defendant's state of mind. He will be simply reporting based upon how he interacted and observed, which consequently led to him arresting the defendant.
All right, what exactly will Officer Wentz be testifying to?
He will be testifying based upon what the defendant said and how he behaved and how that ultimately affected his course of conduct.
Okay, no, but I guess my question is, give me an offer of proof. What specific testimony do you plan on eliciting from Officer Wentz?
Officer Wentz will be testifying to questions that the defendant asked him and also what he reported to the dispatcher and then to Detective Booth.
Okay. I'm asking you for specifics. So you're telling me generally what he's going to testify to. So I want, but you know, the devil, as they say, is in the details. So if Officer Wentz, for example, were going to testify that he saw the defendant turn around and walk over to a pillar and start talking to a pillar, I think that would be admissible. If, on the other hand, Officer Wentz was going to say, I think the defendant was suffering from a mental disease, that wouldn't be. If Officer Wentz was going to say something that was kind of in the middle, like he was acting crazy, that may or may not be admissible depending on the context. So that's why I'm asking you for the specifics.
Yes, Your Honor. Officer Wentz will be testifying that the defendant, when he exited his vehicle, was walking very slowly, blank stares, avoiding eye contact, speaking in a monotone voice, did a single jumping jack, put his hand over his ears like a little kid, then asked if he was with the CIA, claimed he heard sirens coming after him, and also how Officer Wentz had to tell him multiple times that he was not with the CIA. He was, in fact, a Skelton police officer. And he will be saying that he did appear crazy and off, but he is not stating any sort of scientific or medical terminology. These are colloquial terms that lay people use to describe other people's behaviors.
Okay, Ms. Pasculo, do you have any issues with that proposed testimony?
Not have an issue if he testifies to his actual observations. However, anything that's characterizing the defendant as being crazy or off, that's the part of the expert to testify to. That's not for a lay witness.
Okay, so if I'm hearing you correctly, then the two statements that Ms. Yanez gave us that you do take issues with are the statement that he was crazy, that Mr. Ray was crazy, and the statement that Mr. Ray was quote unquote off.
Yes, Your Honor.
All right, I'm going to overrule the objection. I'm going to allow that evidence in. Saying that someone is off, I don't think that's that really even approaches the threshold of an expert opinion. Using the term crazy, I think, is a little bit closer, but still, I think that it's such a commonly used term that, at least the way that I'm hearing it right now, it sounds as if it's coming up as vernacular as opposed to any sort of a mental health diagnosis. So based on that, my indicative is to let it in. If you feel that the evidence is coming out in a way that changes or that would change my analysis, you can certainly feel free to re-raise your objection at that time.
Yes, Your Honor.
Does the prosecution have any other motions?
No, Your Honor.
No.
All right. Now, I believe, Mr. Ward, you said you had some housekeeping issues as well?
Yes, Your Honor.
Right.
First off, the parties have agreed to pre-marked exhibit numbers. The state would like, regardless of how the evidence is introduced, to keep those pre-marked exhibit numbers.
All right, the exhibits will retain their pre-markings. I understand that they may be coming in out of numerical and or alphabetical order, but we will deal with that. I think our jurors are smart enough to deal with that.
Yes, Your Honor. Second, Your Honor, in light of the fact that this trial is being conducted virtually, the local rules aren't clear as to whether or not there will be a Zoom tile representing the defendant. How shall the state properly identify him for the court?
Well, let me ask this. Ms. Yanez, Ms. Gavazi, do you all agree for purposes of this trial that the defendant, or will you stipulate that Mr. Ray that has been properly identified and that any witnesses and or counsel may refer to him as the defendant or as Mr. Ray?
Yes, Your Honor, so stipulated.
Okay. So counsel, I think for prosecution's purposes, the defendant has been identified.
Yes, Your Honor. Your Honor, third, would you prefer a formal tender of the expert witnesses or just lay the foundation and continue?
I don't need you to tender the witness as an expert. You can lay the adequate foundation if counsel for either side feels that inadequate foundation has been laid. You may certainly object when and if there is an opinion or that's asked for that you feel hasn't been covered by the foundation that's been laid by counsel.
Yes, Your Honor. Finally, the state requests that all evidentiary arguments be heard constructively outside the presence of the jury.
They will be heard outside the presence of the jury constructively. However, I do wish for you to ask to approach so that we can clearly differentiate between when we are at sidebar and when we are in front of the jury. So I'm going to ask you to approach, but obviously you're not going to be walking through the camera into my living room. So
yes,
once you've asked to approach, that'll be deemed a constructive sidebar.
Understood, Your Honor.
All right. Any other housekeeping matters for the government?
Not from the state, Your Honor.
All right. What about from the defense?
Yes, Your Honor. May we move out the courtroom as long as we are within the screen?
You can stand up, sit down during examinations. You can move. We just need to make sure, obviously, that you stay within camera view.
And pursuant Federal Rule of Evidence 615, may we ask that all non-party, non-essential witnesses be constructively sequestered from the room?
Any objection from the prosecution?
Yes, Your Honor. The state objects to the expert being sequestered. They are an essential witness in this case, given that the case is an insanity defense.
All right. My inclination, Ms. Gavazzi, is to allow the expert witnesses to remain.
Of course, Your Honor. Yes, we would additionally ask that too. We just ask all non-essentials. So for this case specifically, Detective Booth and Officer Wentz.
Right. Any objection to that, Mr. Ward?
No objection, Your Honor.
Okay. Then without objection, I'll go ahead and order that those two witnesses be excluded.
Your Honor, may we assume that all witnesses are constructively sworn?
Yes.
And may we have the witness reference the electronic notebook when we are impeaching, refreshing recollection, or laying foundation for exhibit, rather than sharing the relevant portion on the screen?
Yes.
And Your Honor, we do have an exhibit that we're going to be using during opening statement. May we use it? We've already spoken with opposing counsel and there's been no objections.
What exhibit is it?
Your Honor, it's a small Prezi presentation. If you'd like more specifics, it's just a few bullet points of what is considered,
Okay.
What's consistent in my opening statement.
Okay. And there's no objection from the state?
Well, Your Honor, so long as the defense introduces this presentation as the evidence will show, it's not appropriate for the jury to be misled that a demonstrative of evidence that's not already in evidence is appropriate to reference.
Well, I guess I'm unclear. There's a difference between the words that she says and the presentation that she plans on using. So my question right now is just about the presentation that they plan on using. Do you have any objection to that?
Not to the demonstrative itself, no.
Okay. Then that'll be fine, and we'll deal with any objections to the substance of either what's on there or the substance of what you're saying, obviously, as we go throughout the opening statement.
No further housekeeping from the defense, Your Honor.
All right. Are both parties ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Okay. We will now hear opening statements from each party. I'd like for everyone to make sure that they are in speaker view. That button should be at the upper right-hand portion of your screen. Attorneys, please remember to mute your audio when the other attorney is speaking. And just to be clear, the only people that should be on video, the only advocates that should be on video are the two advocates presenting opening statements. All right, so actually I need both advocates that are presenting opening statements. So whoever's opening for the defense should be on screen as well.
I apologize, Your Honor. I just had to sit down.
Oh, no problem. All right, so Mr. Ward, you may proceed whenever you're ready.
Yes, Your Honor. A moment just to set up my second camera.
Certainly. right, Counselor, are we ready to proceed?
Yes, Your Honor.
Right.
How to get rid of a body. Will bleach destroy a body? Countries that don't extradite for murder charges. These are the search terms that the defendant, Timothy Ray, put into his phone with the lifeless body of his son just a short distance away. These are the terms that the defendant entered into his phone to try and get away with murder. Nathan Ray was a 6-year-old boy who liked Legos, drawing with crayons, and whose favorite cereal was Frosted Flakes. Wednesday, October 17th, 2018, started as a typical school day for Nathan. Nathan was having his favorite cereal for breakfast when he made an innocent mistake, one that small children often make. He spilled his juice, accidentally damaging his dad's work laptop. This, however, enraged the defendant, who decided to punish Nathan. First, the defendant yelled at Nathan until Nathan started crying and ran to his room. Then, the defendant followed Nathan and ordered him to do strenuous physical exercises until given permission to stop. Nathan couldn't keep up and wouldn't stop crying, so the defendant went to his own bedroom to think about how to punish Nathan further. Then the defendant went over to his dresser, grabbed one of his belts, and went back to Nathan and began to hit him with it. Nathan wouldn't stop crying, so the defendant took his belt, put it around Nathan's neck, and pulled it tight until Nathan stopped crying, stopped moving, stopped breathing. Then the defendant attempted to dispose of the evidence and was only caught with the burial and cleaning tools in the back of his car because he happened to be stopped at a police sobriety checkpoint. You're going to hear from Detective Booth, the lead investigator in this case, who will testify before you today. Detective Booth is a homicide detective and a career law enforcement officer, born and raised here in Skelton. You will learn from Detective Booth that he arrested the defendant 2 days after the murder at a police sobriety checkpoint. You will also learn that the defendant confessed to Detective Booth that he had killed his son and tried to get away with it by burying the evidence. You will learn that Detective Booth found the murder weapon in the defendant's home, as well as a bloody shovel, bleach, and garbage bags in the defendant's car. You will also learn that Detective Booth and K-9 officers found 6-year-old Nathan Ray's body freshly buried in Brandywine State Park. Now, as you already know, and as His Honor instructed you again this morning, as the state, our burden is to prove the guilt of the defendant, Timothy Ray, beyond a reasonable doubt. That means we must show you, members of the jury, that the defendant caused the death of Nathan Ray deliberately or with callous disregard for his life. The evidence will show you that the angry defendant thought about not doing it and then did it anyway. The evidence will also show you that the defendant attempted to cover up his crime by cleaning the scene with bleach, by burying his son in a shallow grave. Now, this case is a little different. We anticipate that everything I just told you is largely undisputed. So, why are we here? Why is there a trial at all? We are here because the defendant has asserted an insanity defense. Because the defense doesn't dispute that the defendant killed his son, they're going to try and convince you that he shouldn't be held responsible for his actions. Members of the jury, when I say convince you, I mean just that. It is the defense's burden to convince you that the defendant couldn't tell the difference between right and wrong. Convince you that he didn't understand the consequences of his actions because he was suffering from a bout of insanity. A bout of insanity that we anticipate the defense will attribute to schizophrenia, a disease the defendant has never before been diagnosed with. The defense will be unable to meet their burden because their theory is not supported by the evidence. We will call an expert, Dr. Mac LaGreca, to testify to the defendant's mental health. Dr. LaGreca is an experienced psychiatrist who trains other psychiatrists. Dr. LaGreca will tell you that the defendant never exhibited symptoms of schizophrenia, and any symptoms that he exhibited after the murder were a last-ditch attempt to get away with this crime. Members of the jury, while you will hear lots of medical terminology and expert testimony throughout the trial today, don't leave your common sense at the door. Use your own common sense to see clearly what the evidence shows about the defendant's mental state. You will learn from Detective Booth that the defendant spoke coherently and candidly with him at the sobriety checkpoint, that he answered all of Detective Booth's questions, that he appeared to understand exactly what Detective Booth was asking him and expressed remorse for murdering his son. When the defense tries to convince you that the defendant didn't know what he was doing, remember the three phrases that the defendant searched for on his phone the day after the murder. How to get rid of a body, will bleach destroy a body, countries that don't extradite for murder charges. The evidence shows that the defendant knew exactly what he had done and was desperate to do anything he could to get away with it. At the end of this trial, my co-counsel, Ms. Pasquillo, will come before you. She will come before you to ask that you hold the defendant accountable for the murder of his 6-year-old son.
Objection, Your Honor. This is the 5th time that counsel has used the term murder. That is a legal conclusion.
Overruled.
She will come before you to ask you that you hold the defendant accountable for the murder of his 6-year-old son, Nathan. That you reach the only verdict that the evidence supports. That you find the defendant guilty of murder in the 1st degree. Thank you.
All right, defense, do you wish to present an opening statement at this time?
Yes, Your Honor.
All right, Mr. Ward, I'm going to need you to turn your camera back on.
Yes,
there you go. Perfect. All right, Ms. Gavazzi, you may proceed.
May it please the court? Counsel? Ladies and gentlemen of the jury, Mr. Ray is sick. He has a disease, but his disease isn't of his heart, and it's not of his lungs. Mr. Ray's disease is of his brain. I mean, his illness, it dictates how he thinks, how he feels, and ultimately even how he acts. Every single day, Mr. Ray has to fight against the things that he sees that are not there, and the constant voices that he hears when no one is speaking to him. Ladies and gentlemen, you'll learn that unfortunately, Mr. Ray has severe schizophrenia. Good afternoon. My name is Sandra Gavazzi, and along with my co-counsel, Palomi Inez, we represent Mr. Timothy Ray. Now, make no mistake, ladies and gentlemen, we are here for the tragic loss of a young life. Well, you see, when someone has schizophrenia, they experience a constant tug of war in their brain. I mean, at times they may be able to pull the rope closer to reality, but at other times that rope just slips right out of their grasp. And that's exactly what happened to Mr. Ray on October 17th, 2018. You'll learn that Mr. Ray's schizophrenia, it prevented him from truly understanding what he was doing that day. That morning, Mr. Ray had made his son Nathan a breakfast, a bowl of cereal, a glass of apple juice, and unfortunately, Nathan did spill his juice on Mr. Ray's work laptop. Now, the average parent would have been frustrated. They would have yelled at their child, but ultimately, they would have just wiped up the mess and carried on with their day. But Officer Wentz will take the stand and he'll tell you that Mr. Ray, he doesn't behave as the average person. No, that's because Mr. Ray has severe schizophrenia. So once the juice spilled, Mr. Ray heard a voice that told him, Nathan spilled the juice on purpose. Nathan is trying to sabotage you. Jessica tricked Nathan. Ladies and gentlemen, the evidence will show that those voices weren't real. No one said that to Mr. Ray. But to him, those voices were more than real. They were loud, and they were powerful. They were overbearing. And members of the jury, those voices didn't stop. As the prosecution said, Detective Booth will take the stand, and he'll tell you exactly what those voices said to Mr. Ray on October 17th. Make Nathan understand. Punish Nathan. Kill Nathan. Mr. Ray lost touch with reality. He could no longer discern the real from the fake. He just wanted to make the voices stop. And to prove to you just how severe of a mental illness that schizophrenia is, we brought you Major Shane Riley, a 17-year licensed psychiatrist who is not only a military veteran, but who has treated hundreds of military men and women like Tim, men and women with severe mental illnesses, including schizophrenia. In fact, Major Riley will tell you that all of the symptoms that Mr. Ray experienced over the course of his life. And she'll tell you that sadly, those symptoms, they went untreated and they led to a psychotic break. The psychotic break that brings us here today. Members of the jury, the evidence will show there was no motive for this act. And the prosecution, they won't be able to give you one. The prosecution wants you to believe that this is some kind of case about a cold-blooded killer, someone who wanted to get back at their son for spilling apple juice by killing him. Members of the jury, ask yourself, does that make any sense? Does that follow any type of logic? The answer is so simple. It doesn't. None of what Mr. Ray did that day makes any sense. And you'll soon see why. Because Mr. Ray was unable to appreciate what he was doing or that it was wrong. Now, at the end of this trial, my co-counsel will come back before you, and she'll ask you to return a verdict. A verdict that tells the prosecution that they can't trick you. A verdict that shows that you truly understand just how debilitating that schizophrenia can really be. A verdict that justice demands. Ladies and gentlemen, find Mr. Ray not guilty. Thank you.
All right. Before the state calls its first witness, I'm going to ask everyone to switch to gallery view. That button should again be found in the upper right of your screen. That will allow you to see the attorneys and the witnesses at the same time. Right, perfect. With that, will the prosecution please call their first witness?
Yes, Your Honor. The prosecution calls Detective Blake Booth to the stand.
All right, and here we are, perfect. All right, Detective Booth, you are sworn. Will you please make sure that you keep your voice up? And whenever you're ready, Mr. Ward, you may begin.
Good afternoon. Please introduce yourself to the jury.
Good afternoon, counsel. My name is Blake Booth.
What do you do for a living, Mr. Booth?
I'm a detective for the Skelton Police Department.
How long have you been employed by the Skelton Police Department?
23 years.
How long have you been a detective?
8 years.
And which unit are you currently assigned to?
The homicide unit.
Detective, how did you come to be involved in this case?
I was the lead investigator assigned to the murder of Nathan Ray.
How did you first get involved?
I received a call that a suspect in a missing persons case was apprehended at an evening sobriety checkpoint.
And Detective, who was that missing person?
6-year-old boy named Nathan Ray.
And who was that suspect that was apprehended at the checkpoint?
Nathan Ray's father, Timothy Ray.
Now, Detective, the defendant has already been identified. So, Detective Booth, did you know who Timothy Ray was prior to his involvement in his son's murder?
I did, yes.
Did you know who Nathan Ray was?
Yes.
How did you know them?
Our sons went to the same school and they played soccer together. And I saw them both at soccer games a couple of times.
Now, Detective, bringing you back to the night of October 19, 2018, what, if anything, did you do when you learned that there was a suspect in a missing persons case detained at a sobriety checkpoint?
Well, I drove from my house to the checkpoint.
When you arrived, what did you see, Detective?
I saw the defendant handcuffed on the side of the road, sitting on the side of the road, with his car pulled off to the side of the road as well.
Was the defendant screaming?
No, he wasn't.
Did you observe the defendant thrashing about?
No, he was sitting upright on the side of the road.
Detective, what, if anything, did you do at the scene?
I walked over to the defendant, told him that I needed to take him down to the police station for questioning.
What was his reaction, if any?
He said, "I understand. I'll tell you everything." And then he started to cry.
Now, Detective, at this point, did the defendant mention anything about hearing voices?
No, he did not.
Objection relevance, Your Honor.
Overruled.
Detective, at this point, did the defendant Detective, at this point, did the defendant mention anything about hearing voices?
No, he didn't.
Did the defendant do or say anything that made you believe that he needed medical or psychiatric attention?
No.
At this point, was he doing anything that appeared abnormal to you?
No, he was just sitting there.
Detective, what did you do next?
I had him transported down to the police station so that I could interview him.
And once you arrived at the precinct, what did you do?
I Mirandized the defendant and asked him to sign a written Miranda waiver stating he understood his rights, which he did.
Detective, was that interview recorded?
It was, yes.
Did you preserve that recording?
I had the audio transcribed, but the video was automatically deleted.
Why didn't you preserve the AV?
Well, because I preserved the statement of the because I preserved his statement in the transcript. There's nothing about the defendant's behavior that required me to preserve the video.
Detective, during your interview, what did the defendant tell you?
He told me that he murdered his son, Nathan, by strangling him to death with a belt in his home.
Objection, Your Honor. Murder is a legal conclusion. The witness cannot testify to whether or not Mr. Ray murdered his son.
Sustained. Detective Booth, will you please refer, you can tell us what the defendant said. If he used the word murder, then that's one thing. If he did not, then just tell us what he said, please.
Your Honor, additionally, I apologize. I also have the witness's statement stricken from the record.
The answer will be stricken.
Detective, I'm going to ask you the question again, and please keep in mind the judge's ruling on this issue without using the term murder or any other conclusions of law. Now, Detective, during this interview, what did the defendant tell you?
He told me that he killed his son, Nathan, by strangling him to death with a belt in his house.
Detective, did he explain why?
Yes. Ray said that his son spilled apple juice on his laptop the morning of October 17th. And that he spilled the juice because the boy's mother, the defendant's ex-wife, told him to. Ray then said he felt he had to discipline his son, which ultimately led to him strangling his son.
Objection, Your Honor. This is multiple levels of hearsay. The witness has testified to what Mr. Ray told the officer, and additionally what, if I'm understanding the testimony correctly, what Jessica Ray told Mr. Ray.
Your Honor, these are the statements of a party opponent.
So just to be clear, these are the statements that the defendant told Detective Booth?
That's correct.
Overruled.
Your Honor, I apologize, there are multiple levels of hearsay, though, if I understand the witness's testimony correctly. He mentioned that Jessica Ray told him that he tricked his son, unless it was misworded.
Your Honor, to the extent that the defendant, that the detective is recounting what the defendant told him during the interview, the statements by Jessica Ray are not being offered for the truth. They're being offered for the effect on the listener as to why the defendant did what he did.
The objection's overruled.
Detective, did the defendant explain why?
Yes. Ray said that his son spilled apple juice on his laptop in the morning of October 17th. And that his son spilled the juice because the boy's mother, defendant's ex-wife, told him to. Mr. Ray then said that he felt that he needed to discipline his son, which ultimately led to the defendant strangling his son.
Detective, how did the defendant say he attempted to discipline his son?
Objection
First-
relevance, Your Honor.
Response?
Your Honor, the defendant's explanation to Detective Booth of his attempt to discipline his son is highly probative of a motive to murder his son.
I'm not sure that I buy that. I do think it's relevant, though. These are the events immediately surrounding the murder, correct?
Correct.
I may be
Overruled.
heard. Oh, okay.
Okay. No, go ahead.
Oh,
Go ahead, counsel.
the fact that Mr. Ray did punish his son may be relevant. However, how he punished his son is not relevant to this matter.
I'm going to overrule the objection. I think that the manner in which he punished his son does have some tendency and reason to shed light on material issues in his case. So I'm going to overrule the objection.
Detective, how did the defendant say that he attempted to discipline his son?
First, by making the boy do jumping jacks for a while. Then the defendant made the boy run in place while doing high knees. And then the defendant started to beat his son with a belt.
What did the defendant say he did next?
Defendant said his son told him that he hated him. The defendant then took the belt that he had been using to whip his son. He wrapped it around the boy's neck, and then he strangled him until he died.
Detective, did the defendant tell you what he did with Nathan's body after killing him?
He did. He told me that he put Nathan's body in his car and buried him in Brandywine State Park.
Detective, did you take any other steps in investigating the defendant's claim that he had killed his son?
Yes, we took a number of steps. First, we searched Brandywine Park and found Nathan's body. Second, I obtained a warrant for the defendant's car and searched it. And then third, I obtained a warrant for the defendant's phone and investigated the defendant's search history.
Directing court and counsel to pages 106, 98, 99, and 57 to what have been pre-marked for identification as exhibits 29, 21, 22, and 10. Detective, do you recognize these photographs?
I do.
What are the photographs of?
Exhibit 29 is a photograph of Nathan Ray. Exhibit 21 is a crime scene photo from where we recovered Nathan's body in Brandywine Park. Exhibit 22 is a photograph of the items we discovered in the backseat of the defendant's car. And Exhibit 10 is a screenshot of the defendant's phone search history.
Detective, how do you recognize them?
Exhibits 21, 22, and 10 are photographs that I took during the course of my investigation. Exhibit 29 is a photo of Nathan. And I knew Nathan, as I mentioned, from my son's soccer games. The photograph or more of Nathan was provided by Nathan's mother when she filed the missing persons report. And yeah.
Detective, are these photographs fair and accurate representations of Nathan Ray himself, the crime scene at Brandywine State Park, the backseat of the defendant's car, and the defendant's cell phone search history?
They are.
Your Honor, the state offers exhibits 29, 22, 21, and 10 into evidence.
This time, Your Honor, defense renews our objection in our motion in limine, while additionally objecting to the image of the trash bag that was found in Brandywine State Park, as it is substantially more prejudicial than probative.
Okay, let's deal with that one first. That was exhibit 21, correct?
I believe so, Your Honor.
Okay, and your objection is 403?
Yes, Your Honor.
Your Honor.
All right. I'm sorry, go ahead, counsel.
Your Honor, the photograph of the crime scene and the victim's body in the park is highly probative of murder, and specifically showing remorse or guilt, trying to get away with it.
Okay, I'm sorry. I'm going to need, I guess, a little bit more explanation on how exhibit 21 shows remorse.
Your Honor, focusing for a moment, I guess, on the fact that it's highly probative that someone who had murdered someone and who was trying to get away with it is going to try to dispose of the evidence, in this case, burying the evidence.
And that shows remorse?
Your Honor, I misspoke. It does not.
Okay, so then what does it show?
It shows that the defendant understood the consequences of his action.
Okay. Ms. Gavazzi, what's the prejudicial impact of this evidence?
Your Honor, in the photo, you can see, or if I first may be heard outside the presence of the jury.
Okay, we're approached.
Okay, thank you, Your Honor. First, the photo, it shows shoes in the picture, and they are obviously indicative of Nathan Ray. Additionally, Your Honor, I don't see the relevance in this picture as being introduced. There's no question as to whether or not Nathan Ray is dead.
Okay, so is your objection relevance, or is your objection that it's unduly prejudicial?
Both, Your Honor.
Okay, then let's back up a step even further, Mr. Ward. Why is this? Well, actually, you've already explained why it's relevant. I think the state's argument, if I understood it correctly, is that it essentially shows consciousness of guilt on the part of the defendant. So I do think it's relevant. What's the prejudicial impact of it, though?
Again, Your Honor, there's shoes that, I apologize. There are shoes that are protruding from the garbage bag. There's very clearly a body in that bag. The jury does not need to see that picture. They already have a picture of Nathan alive. And again, there's no question as to whether or not Nathan has passed away at this point.
But I guess I'm still not seeing the prejudicial impact of the shoes. I mean, I think we know there's a body, and I think that's the point that the state is making, is that there is a body in it. So I guess I'm failing to see how seeing those shoes somehow makes the picture unduly prejudicial to the extent that it indicates that there's a body in there, if the whole point of the photograph is that there's a body in there. I'll give you the last word, though.
I mean, other than the fact that it stirs the jurors' emotions, Your Honor, we rest on the argument.
All right, I'm going to overrule the objection to exhibit number 21. And then with exhibit 10, do you have any additional argument, or is it the same argument that you made in pretrial, essentially, that there hasn't been any
Yes, Your Honor.
foundation that the searches were conducted by Mr. Ray?
Yes, Your Honor, there are some additional foundational issues with the introduction here. Since we are still outside the presence of the jury, Your Honor, there has been no testimony about when this phone was recovered, nor when the forensic analysis was run on it. So again, there is this exorbitant amount of time that the phone was unaccounted for, and that is extremely prejudicial within itself, but that is an issue in foundation for this exhibit.
Your
Mr.
Honor,
Ward, do you wish to be heard?
Yes, Your Honor. Your Honor, opposing counsel is mischaracterizing the contents of the record in the stipulation. The stipulation clearly states that the forensic analysis of Timothy Ray's phone was conducted on October 22nd, 2018. To say that we don't know when that forensic analysis had taken place is disingenuous.
Your Honor, that stipulation has not been read into evidence at this time, especially not in front of the members of the jury.
I understand that it hasn't been read into evidence, but you did stipulate to it, which means whether the jury knows it or not, you've agreed that that is, in fact, when the analysis took place. So, I do think that it is inappropriate to argue that we don't know something when you have, in fact, agreed that we do know it. So I'm going to overrule the objection. Exhibit 10 is admitted as well.
Yes, Your Honor. Your Honor, permission to publish Exhibit 21 already in evidence.
You may.
Detective, what did we just see in Exhibit 21?
It was a shot of Nathan's body. We sent a K-9 unit into Brandywine State Park. One of the dogs found Nathan's body inside the black garbage bag that we saw in a shallow hole, partially obscured by dirt on top of it.
Your Honor, permission to publish Exhibit 22 already in evidence.
You may.
Detective, what did we just see in Exhibit 22?
This is the defendant's backseat of his car. And we performed a search of the defendant's car, and we found the bleach, shovel with what appeared to be dried blood on it, and black garbage bags. Again, in the backseat of the car.
Detective, turning to the Exhibit 10, the cell phone searches. Now, what, if anything, did the search of the defendant's phone yield?
In the defendant's search history, we found 3 particularly relevant searches.
Your Honor, permission to publish Exhibit 10 already in evidence.
You may.
Now, Detective, what were the searches that you were able to recover from the defendant's cell phone?
There were 3 in particular. He searched on October 18th. 1, countries that don't extradite for murder charges. 2, how to get rid of a body. And 3, will bleach destroy a body?
Nothing further, Your Honor.
All right. Cross-examination.
Detective Booth, you were previously asked some questions about Exhibit 10. You stated that these were screenshots of the defendant's phone, but you can't say when you recovered this phone, can you?
We recovered the phone as part of my investigation after October 19th.
But you don't know the date that it was recovered?
I can't give you a specific date, no.
And you don't know where the phone was from the date that it was recovered until the forensic analysis was run on it?
It was in police custody.
Okay, detective. You've been a detective for 7 years now, correct?
8 years, actually, counselor.
8 years. And you've had the opportunity to investigate 12 homicide cases at this point.
That's correct.
Countless gang cases,
That's correct.
countless drug cases.
Sure.
Detective Booth, it's fair to say that you know how to conduct an interrogation.
Yes, I would say so.
So you know that the first thing that you have to do is read a suspect their Miranda rights.
That's correct.
Detective, it is your duty to make sure that that individual understands what his rights are.
That's correct.
It's your duty to make sure that that individual understands what it means to waive his rights, correct?
That's correct.
Well, let's talk about how you informed Mr. Ray of his rights on October 20th, 2018. Detective, you gave Mr. Ray Skelton Police Department's Miranda warning and waiver form.
Correct.
And it took you 12 whole minutes to go over that form with Mr. Ray.
I don't recall the exact amount of time.
Detective Booth, you signed that form stating that you gave it to him at 1:56 a.m. Correct?
That's correct. That's correct. Yeah.
And he signed the bottom of the form at 2:08 a.m. Detective Booth, it took you 12 minutes to go over 5 Miranda warnings with Mr. Ray.
It would appear so. Yes.
And you claim that Mr. Ray wasn't confused during that time.
He was responding to me coherently and cogently.
You claim that he didn't ask you any questions during that time.
That's correct.
Detective Booth, you claim he completely understood everything that you said to him during that time.
Based on my observations, yes.
But we'll never know what actually happened during those 12 minutes, will we?
Your Honor, objection, speculation.
Overruled.
Detective Booth, we will never know what happened during those 12 minutes, will we?
If you want to ask me questions about it, counselor, I can answer questions about that period of time.
Well, you never recorded that 12 minutes, did you?
No, the recording didn't start.
I apologize. You didn't even make a transcript of those 12 minutes.
That's correct.
But to be clear, Detective, that interview room was equipped with audio and video recording equipment.
That's correct.
Now, Detective Booth, after you gave Mr. Ray his Miranda form, you then interrogated him.
I interviewed him, yes.
And you did record that interrogation.
Yes.
But that recording didn't occur until 9 minutes after Mr. Ray had already signed his Miranda form.
Recording started, I believe, at 2:10.
Detective Booth, the recording started at 2:17 a.m., isn't that correct?
I believe I read into when I introduced myself and on the recording, I believe I said it was 2:10 in the morning.
Okay, Detective, well, we'll go with your measurement then. So if my calculations are correct here, Detective, 12 minutes for Miranda form and 4 or 5 minutes here, that's a total of 16 minutes in which you interacted with my client, which were never recorded. Is that a yes, Detective?
Yes.
Now let's talk about what you did manage to record that evening. You recorded the 20-minute interrogation with Mr. Ray,
That's correct.
but you didn't preserve it.
I preserved the transcript of the audio.
You didn't preserve the audio or video recording for the only recording that you made all night.
That's correct.
If I may have a minute, Your Honor.
Okay.
Let's talk about why you didn't record, or excuse me, why you didn't preserve those recordings, Detective. You have a history with Mr. Ray.
I first met him in August 2018.
You mentioned that your son played soccer with his.
That's correct.
And during those soccer practices, you tried to talk to Mr. Ray.
Once or twice, yes.
He wouldn't even hold a conversation.
That's correct.
He wouldn't ask you any questions about yourself,
Generally, no.
none about your family.
Yeah, generally, no.
Kept giving you one-word answer.
That's correct.
Detective Booth, he was unkept, correct?
Based on my observations, yes.
He had bad hygiene.
It appeared so, yes.
It's fair to say, Detective, that you and Mr. Ray were not friends.
That's fair.
And yet you claim that he just confessed to you during your interrogation of him.
I claim it because he did.
Detective Booth, during that very interrogation, Mr. Ray asked you if you were part of the CIA.
That's correct.
He asked you that question 3 times,
Yes.
and you didn't find that out of the ordinary.
No.
Detective Booth, Mr. Ray told you that Jessica tricked Nathan into spilling apple juice,
He did mention that, yes.
that some unknown they were telling him these things,
That's correct.
that they told him to make Nathan understand,
That's correct.
that they told him to punish Nathan,
Yes.
and that they told him to kill Nathan.
Yes.
Detective Booth, you didn't find any of that out of the ordinary.
No,
And you didn't even ask who they were.
I didn't.
Instead, Detective, you played along.
If that's how you want to characterize it.
Well, you said to Mr. Ray, he needed to know Jessica couldn't trick him. I get that. I see where you're coming from. Is that a yes, Detective?
Yes, I said that.
Oh, I apologize.
No,
You said to Mr. Ray, she had him tricked too good if he was saying that.
I said that, yes.
Those are your words.
Correct.
You falsely assured Mr. Ray so that he would confess.
I don't know if I would characterize my statements in that way.
After all of that, Detective, you called Mr. Ray a piece of shit.
I did say that.
You told Mr. Ray that he'd be better off dead.
Yes, Counselor, I said that.
Nothing further, Your Honor.
Are there any further questions?
No, nothing further, Your Honor.
Okay, I'm sorry, I did not hear you.
Oh,
All right, any
apologize.
redirect?
No, Your Honor. The state does not need to redirect this witness.
All right, next witness.
Your Honor, at this time, the state calls Dr. Mac LaGreca.
All right, Dr. LaGreca.
Good afternoon. Could you please introduce yourself to the jury?
My name is Dr. Mac LaGreca.
And what do you do?
I'm a doctor specializing in the field of forensic psychiatry.
You a licensed psychiatrist?
Yes, I am licensed in 3 states, including West Carolina.
You board certified in any areas?
Yes, I am board certified in forensic psychiatry.
You please tell us a bit about your educational background?
I earned a Bachelor of Science in Chemistry at the University of Delaware. After that, I went to medical school at the Perelman School of Medicine at the University of Pennsylvania.
After finishing medical school, did you participate in a residency program?
Yes, I did my residency in general psychiatry at the David Geffen School of Medicine at the University of California, Los Angeles. I then returned to the University of Pennsylvania to complete my forensic psychiatric fellowship at the Perelman School of Medicine.
What did you do after your fellowship?
I started my own private practice, LaGreca Psychiatric Associates, where I worked for 23 years.
And what do you do now?
I am in academia full-time. I'm the program director of the West Carolina School of Medicine's Forensic Psychiatry Fellowship Program, and I oversee the general psychiatry rotation for the medical students. And I also treat patients once a week at the Jamie Spears Hospital, which is affiliated with the University of West Carolina.
Have you ever been an expert witness before?
Yes, I have, 7 times in criminal cases.
How many of these cases dealt with schizophrenia?
3 dealt with schizophrenia.
Have you applied all of the principles and methods that you learned over the course of your career to the facts of this case?
Yes, I have.
How did you become involved in this case?
I was retained by the state of West Carolina to provide an opinion regarding Timothy Ray's mental health.
Did you rely on the principles and methods that are standard in your field in arriving at this opinion?
Yes.
What materials, doctor, did you review in coming to your opinion?
The DSM-5 and the joint exhibit list, including the summary of Major Riley's interview with the defendant that is contained within his report. And I also use materials and information referenced in my own report.
Were you able to come to an opinion to a reasonable degree of medical certainty?
Yes.
All right, Dr. LaGreca. So now I want to talk to you a bit about your evaluation. What is your opinion as to the defendant, Timothy Ray's mental health?
I concluded to a reasonable degree of medical certainty that the defendant was not schizophrenic and was malingering.
How did you reach that conclusion?
I reached that conclusion for 3 reasons. First, there was no previous diagnosis of schizophrenia. Second, there was no evidence or record of the defendant showing signs of schizophrenia in the past. And then third, the defendant didn't show any symptoms during his interview with Major Riley, and any symptoms the defendant did show can be attributed to malingering.
Okay, Dr. LaGreca, let's take those one at a time. You mentioned there's never been a previous diagnosis of schizophrenia. What is the significance of a previous diagnosis in a case like this?
Well, without a previous diagnosis, you have to make a diagnosis based on the person's symptoms reported after the fact. So when there is no diagnosis or documentation of symptoms before an incident, it increases the likelihood that someone is malingering.
And how is schizophrenia diagnosed?
By determining whether the person shows the symptoms laid out in the DSM-5.
And what is the DSM-5?
It's a manual for the assessment and diagnosis of mental disorders, and it is published by the American Psychiatric Association.
How do you know that the defendant has never been diagnosed with schizophrenia?
Because there is no mention of schizophrenia in any of his medical records by the 3 doctors who evaluated him, who were Major Riley, Dr. DiGiuseppe, and Dr. Narasimhan.
What was the result of when those 3 doctors evaluated the defendant?
Major Riley diagnosed the defendant in 2010 with generalized anxiety disorder, not schizophrenia. And Dr. DiGiuseppe saw the defendant between 2010 and 2017 and she never diagnosed him with any mental illness, nor did she prescribe him any medication. And Dr. Narasimhan saw the defendant on November 12, 2019, after the defendant killed his son and after Major Riley conducted his clinical interview of the defendant. Dr. Narasimhan also made no diagnosis and only prescribed medication for depression and anxiety.
Was the defendant ever hospitalized for schizophrenia?
No, he was only once hospitalized in 2010 for anxiety and depression due to stress related from being in the military.
What was he diagnosed with then?
Generalized anxiety disorder.
Who diagnosed the defendant?
Major Riley, the defense's expert.
Okay, Dr. LaGreca. So the second reason that you mentioned for your diagnosis was that there was no evidence of the defendant displaying symptoms of schizophrenia in the past. How did you determine that the defendant never exhibited any symptoms of schizophrenia in the past?
I looked at his medical records, his employment history, his education history, interviews of his relatives and his boss, his lack of any criminal history before the incident, his interactions with law enforcement officers, and I also looked at his account of his actions before and after killing his son.
According to these reports and all of the records you reviewed, is there any evidence that the defendant heard voices prior to his clinical interview on September 8, 2019?
No. In fact, the defendant outright denied experiencing those symptoms to Major Riley in 2010.
Based on this same review, did the defendant have any hallucinations, either visually or auditorily, prior to his clinical interview on September 8, 2019?
No.
And based on this same review, did the defendant experience delusions prior to September 8, 2019?
No.
What, if anything, about the defendant's employment history affected your conclusion?
Timothy Ray worked at an electronics repair company for 8 years, and over the 8 years that he worked there, he was never formally disciplined. And in fact, his boss told Major Riley that he was a fantastic employee. This is unusual because those with schizophrenia tend to have difficulty maintaining employment, and the defendant did not have any difficulty doing that.
What, if anything, about the defendant's educational background impacted your conclusion?
The defendant graduated from Skelton University, receiving a bachelor's degree in computer sciences, and he graduated summa cum laude. Those with schizophrenia have difficulty completing education, much less graduate with honors.
What, if anything, about the interviews with the defendant's family or close acquaintances led to your conclusion?
Interviews with the defendant's family conducted by Major Riley did not indicate that the defendant exhibited any symptoms of schizophrenia, nor about the defendant telling them of those symptoms. Schizophrenia tends to be ongoing, with the onset of the first psychotic episode for males manifesting when the person is in their early to mid-20s.
Dr. LaGreca, you mentioned that the third factor that led to your conclusion was that the defendant didn't show any symptoms of schizophrenia during Major Riley's interview of him, and that anything that appeared to be like symptoms you classified as malingering. Let's talk about that interview. When did this interview take place?
September 8, 2019, after the defendant had already been arrested for killing his son.
Was there any record that the symptoms that the defendant reported to Major Riley during that interview were ever observed by friends or family of the defendant?
No.
Were the overwhelming majority of the symptoms that the defendant reported during this same clinical interview ever documented in employment, military, and/or medical records?
No.
How old was the defendant during his interview with Major Riley?
He was 32.
Is it unusual for a schizophrenic not to show symptoms until age 32?
Yes, because according to the DSM-5, the peak age of onset of the first psychotic episode for males is in the early to mid-20s.
The defendant is not a schizophrenic. How do you explain the defendant's self-reported symptoms that are listed in Major Riley's report?
The defendant is likely malingering.
What is malingering?
Malingering is when one is faking symptoms, often to create a legal defense.
How do you know if someone's malingering?
The DSM factors for malingering include, first, the legal context of a clinical assessment. Second, discrepancies between the person's claimed psychiatric disorder and objective findings. And third, failure to cooperate during diagnostic evaluation and failure to comply with treatment.
Are there any factors outside of the DSM that are considered when determining whether one is malingering?
Other factors outside of the DSM need to be considered as well, including evading criminal prosecution and other such incentives.
Okay. And did the defendant display any of the DSM-5 symptoms of malingering?
Yes, 3 of the 4 DSM symptoms of malingering are present in the materials I reviewed by applying the DSM factors relating to malingering to the facts of the case. First, Major Riley's assessment occurred in the context of a criminal evaluation. Second, there exists major discrepancies between the symptoms described by the defendant during the clinical interview and the symptoms, or rather lack thereof, documented in the written materials, including medical records and described by those who knew him best. Major Riley also noted that there were inconsistencies in his account of October 17, 2018, the day of the killing. Finally, the defendant was not cooperative with Major Riley throughout the clinical interview.
Right, doctor. So was there anything that the defendant said to Major Riley that indicated he would have a strong incentive to malinger?
He expressed fear at times, indicating that he knew he was going to jail for what he did.
Are there any other factors that indicated that the defendant was not schizophrenic and was rather malingering?
The defendant attempted to hide evidence of the crime, his internet search history, which included things like countries that don't extradite for murder charges, how to get rid of a body, and will bleach destroy a body. Only hours after the killing plainly indicates his consciousness of guilt, which is further evidence of malingering.
Thank you, doctor. I have no further questions.
Sorry about that. I was on mute. Cross-examination.
May I proceed?
You may.
Dr. LaGreca, you've given expert testimony 7 times before.
That's correct.
6 of those times were for the prosecution.
That's right.
So this case will be your 7th time testifying for the state. Is that correct?
That's correct.
Let's talk about your work here. You would agree, doctor, that in order to properly assess a patient's symptoms and make a diagnosis, you would want to talk to family members of that patient to learn of any history of mental illness.
Yes, but I didn't speak to any family members because there was enough information and enough summaries of family interviews. They were enough for me to make my final conclusion.
You would also want to speak to friends and associates of the patient to learn of any additional symptoms?
Yes, but along those lines, there was enough information contained in the report for me to conclude that he was malingering.
Just to verify, you didn't speak to any of Tim's family members.
Objection, asked and answered.
Overruled. This is Cross.
Doctor, you didn't speak to any of Tim's family members.
I did not.
You didn't speak to any of Tim's friends or associates either.
No, because like I said, there was enough information contained in the joint exhibit list and Major Riley's report.
So you relied upon those summaries.
I did.
The summaries written by our expert, Major Riley.
Yes, but I disagree. Excuse me. I disagree with how Major Riley applied the DSM factors to the facts of the case.
Yet you stated yourself that these summaries were sufficient for you to conclude that Mr. Ray was not experiencing symptoms of schizophrenia on October 17, 2018. Do I have that correct?
You do have that correct. I just disagree with Major Riley's interpretation of his interviews.
Let's talk more about your opinion here. First, you took into account Mr. Ray's medical history.
Yes, I did.
So you're aware that Tim was discharged from the military for mental conditions.
Yes, he was discharged for anxiety and depression, which are not uncommon in military personnel under a high degree of stress.
Well, Tim's commanding officer reported that Tim had a 1-month history of difficulty with sleeping. Isn't that true?
That is true. Correct me if I'm wrong, but I believe Major Riley also noted that Officer Cruz had a tendency to like spin tails or something like that.
Let's focus back upon what I was asking. Tim's commanding officer also reported that Tim had difficulty.
I'm sorry, counsel.
Yes.
I'm going to ask you to stop referring to the defendant as Tim. You can either call him Mr. Ray, you can call him the defendant, but I'd prefer if you not use first name or just his first name. That's a little too informal for my courtroom.
Yes, Your Honor. May I continue?
You may.
Dr. LaGreca, Mr. Ray's commanding officer also reported that he had a 1-month history of depression.
He did, and in the records of Timothy Ray having any sort of hallucinations, that's the only time that it was mentioned. And like I said, Major Riley noted that Officer Cruz is an unreliable historian.
Well, you would agree that disturbed sleep patterns is a symptom that contributes to a diagnosis of schizophrenia.
Sure, but that's an exacerbating factor. And there are many explanations for that, one of which was that he was in the military at that time.
Depression is also a symptom that can contribute to a diagnosis of schizophrenia.
Exactly, but it's another exacerbating factor, but it by itself does not point to a diagnosis of schizophrenia.
Correct, but Mr. Ray was discharged from the military based upon these symptoms.
That's correct.
Now, doctor, you also took into consideration Mr. Ray's childhood trauma.
I did.
His mother was neglectful and cruel.
Yes.
She would often force Mr. Ray to take baths in cold water.
Yes.
She would often refuse to feed him.
That's right.
You would agree that childhood trauma can contribute to a schizophrenic diagnosis.
Sure. But again, it's another exacerbating factor. And a lot of Americans have suffered from childhood trauma without developing schizophrenia. So it by itself does not point to schizophrenia.
Having a family history of severe mental illness can also contribute to a schizophrenic diagnosis.
Sure, but based on the records that are reviewed, only his mother might have had a mental illness.
His mother was institutionalized for that undiagnosed mental illness.
She was institutionalized, but we don't have much record of it. And Abe Ray, Timothy Ray's father, characterized her behavior as mood swings.
You don't have much records of it, but you didn't seek out his mother's records, correct?
I didn't.
Once again, doctor, you would agree that genetics can often play a significant role in a patient having a mental illness.
Sure, and I considered that in this case as well, but we don't have a diagnosis for Timothy Ray's mother.
Well, doctor, you know that Mr. Ray saw his primary care physician, Dr. Giuseppe, 3 times through 2010 and 2017.
That's right.
Ultimately, she referred him to a psychiatrist.
Yes, and that was not surprising because that was the visit around that time that his wife was cheating on him and about to leave him. So it's not surprising that he acted unusual enough for her to be concerned.
She made this referral because after her last visit with Mr. Ray, she thought that he needed more serious treatment.
Sure, but you have to take into account the context of his behavior. His wife was about to leave him and she cheated on him.
Correct, doctor, but we're not here today to discuss Jessica Ray's conduct. We're here to talk about Mr. Ray. Dr. Giuseppe also reported that he looked like a total mess.
Yeah, that was the last visit around what I mentioned earlier when he was going through all those things in his life, like divorce.
And that Mr. Ray needed help from a mental health professional.
That's right.
Unfortunately, Mr. Ray never sought treatment after his last visit with Dr. Giuseppe.
That's right.
Let's talk about how schizophrenia works. Schizophrenic
Okay.
patients can often experience hallucinations.
That's correct.
In 2018, Mr. Ray reported hearing male voices that would randomly pop up.
That's correct, but correct me if I'm wrong, but I believe this was during his interview with Major Riley, where he had a strong incentive to say that he had hallucinations.
Let's focus back upon what I asked. Mr. Ray also reported during that he heard a creepy male voice on October 17th, 2018, that told him to kill his son.
Yes.
A voice that told him that his son spilled apple juice on purpose and was trying to sabotage him.
That's right.
You're aware that schizophrenic patients can often have difficulty functioning.
Yes, I'm aware.
Isn't it true that Mr. Ray threatened to kill a fellow employee at work for not following directions?
Sure, but if you take into account that he was going through a divorce at that time, then it makes sense that his behavior was unusual. But what's even more unusual is that he was working at his job for 8 years, and this was the only time where he showed like any sort of violence towards somebody else.
Now, doctor, you said going through a divorce means that it makes sense. So going through a divorce makes sense to threaten to kill somebody.
Everybody reacts in different ways to news.
Okay, doctor. Well, you would agree that hostility and aggression are associated features of schizophrenia.
That's true. Those are associated features, but by themselves, they do not point to schizophrenia.
Isn't it true that Mr. Ray struggled with interpersonal relationships and self-care in the months leading up to Nathan's death?
Yes, but there can be other explanations for that besides schizophrenia, like the fact that he was about to go through a divorce.
Correct, but we're here today to talk about schizophrenia, not the other explanations. Jessica Ray, his own wife, even reported that Mr. Ray had turned into a completely different person in 2017.
And she did.
She also reported that he would lock himself inside a bathroom for hours, refusing to come out.
That's right.
And that sometimes Mr. Ray would go for more than a week without showering.
That's true.
No further questions.
All right, any redirect?
Yes, Your Honor.
All right,
Dr.
you may proceed.
Dr. LaGreca, you were asked a lot about interviews. Did you have a chance to interview the defendant?
No, I wanted to, but the defendant's attorneys wouldn't allow me to interview him.
Thank you. I have no further questions.
All right, all right, Dr. LaGreca, you're excused. Does the state have any additional evidence?
No, Your Honor. At this time, the state rests, but we would request a time check.
Right, hang on, before we do that, does the defense have any motions to make at this time?
Yes, Your Honor, we do.
All right, you may.
Your Honor, pursuant to Rule 29 of the Federal Rules of Criminal Procedure, the defense brings a motion for judgment of acquittal. Your Honor, even when viewing the evidence in a light most favorable to the prosecution, the state has not presented evidence that is sufficient for a reasonable jury to find first-degree murder beyond a reasonable doubt. First, the prosecution has not presented any physical evidence connecting Mr. Ray to the death of Nathan Ray. We heard about a shovel, bleach, and trash bags found in Mr. Ray's car, but no DNA testing was conducted on the substance on the shovel to prove that it was Nathan's blood. There was no proof that the bleach discovered was ever even used on Nathan, and there was no proof that the trash bags found in Mr. Ray's car were the same that Nathan's body was discovered in. Additionally, there is no eyewitness to the killing, but rather, the prosecution offers only the words of the defendant himself, which the jury will not find credible given Detective Booth's conduct in feeding into Mr. Ray's delusions, which enticed him to confess. Lastly, Your Honor, the prosecution has not proved malice aforethought beyond a reasonable doubt. The state attempted to establish malice aforethought via premeditation. However, the state has not presented any evidence that proves the key sequence of events, which is the consideration whether to kill, the decision to kill, and then the killing arising from that decision. Again, the only evidence offered on this necessary element is the defendant's statement. But for the reasons previously stated, that standing alone is insufficient for a reasonable jury to find this element. Therefore, Your Honor, the defense asks that you grant our motion for judgment of acquittal.
Great. Prosecution, do you have a response?
Yes, Your Honor. In the light most favorable to the prosecution, the prosecution has, through the testimony of Detective Booth, elicited that the defendant himself confessed the murder, as well as elicited premeditation when the defendant told Detective Booth that he went to his room for a few seconds before returning to strangle Nathan Ray. Now, as Your Honor's jury instructions detail, the decision to kill and premeditation can be satisfied with just a few moments, few seconds of contemplation. The state has shown beyond a reasonable doubt that the defendant has murdered his son, Nathan Ray, and that he murdered him with malice aforethought.
Okay. If I don't believe that you've proven premeditation, am I required to grant the motion?
Sorry, I didn't hear you, Your Honor. One more time.
I said, if I do not believe that you've proven premeditation, am I required to grant the motion?
Well, Your Honor, the state has elicited testimony from Detective Booth that satisfies the element of premeditation.
Right. That wasn't my question, though. My question was, if I don't believe that you've proven premeditation, am I required to grant the motion?
I don't know, Your Honor.
All right. I'm going to go ahead and deny the motion. I do believe that there has been sufficient evidence, at least such that a reasonable or rational trier of fact could conclude that the defendant is guilty of the crimes charged. Let's go ahead and, before we go into the defense case, we will take a brief break. It's 12:58 right now by my watch. We'll call it 1 o'clock. I'd like to begin promptly at 1:05. Are the timekeepers prepared to give a time check at this time, or do you need time to calculate and consult with one another?
Your Honor, we consulted together, and the state has used 30 minutes and 33 seconds, and the defense has used 24 minutes and 56 seconds.
Okay, so how much time does that leave each of them from their 55 minutes?
So that should leave for the state 25 minutes and 27 seconds, I believe. And I'll calculate the defense because I can't do that in my head.
Okay. All right. So if you could just have that calculation for them when we come back, I'm sure they'd love to know how much time they have left. And that's probably more relevant to their lives than how much time they've used right now. So we'll be back here in about 5 minutes. That should hopefully give everybody enough time to run to the restroom real quick or do whatever you need to do.
Your Honor, should we post
we'll
the
be in
times?
recess until then.
Sorry, should we post the times in the chat? Times left?
That is completely up to you. I am not keeping time, so that's truly up to you all and to the bailiffs, or to the timekeepers rather.
Thank you.
All right, great. Looks like we have everyone back. Do we have our jurors back? Do we have our 3 jurors back? If we do, either turn your cameras on or shoot me a quick chat answer saying that you are back, please. Okay, that's excellent. Ms. Padilla, Mr. Finkelstein. All right. Looks like we're still missing 1 juror. Mr. Finkelstein. Oh, sorry. Ms. Padilla. Okay, perfect. All right, so it looks like we've got our jurors back. So with that, is the defense prepared to proceed?
Yes, Your Honor. Defense calls Officer Wentz to the stand at this time.
All right. Officer Wentz, consider yourself sworn. You may proceed, counsel, whenever you're ready.
Good afternoon. Please introduce yourself to the members of the jury.
My name is Officer Peyton Wentz.
Where are you employed as an officer?
I'm a patrol officer for the Skelton County Police Department.
How long have you been on the force?
About 2 years now.
Officer Wentz, I'd like to direct your attention to the night of October 19th, 2018. Were you on duty that evening?
Yes, I was.
What shift were you working?
I was working the sobriety checkpoint on the night shift set up on Route 22.
Did anything out of the ordinary occur during your shift that night?
Well, it started off as a pretty boring night, like no DUI arrests or anything like that. But then I encountered Mr. Ray.
Sorry, can you repeat that? I cannot hear you.
It started off as a pretty boring night. There was no DUI arrests, anything like that. But then I encountered Mr. Ray.
What happened when you encountered Mr. Ray?
As his car approached the checkpoint, I walked over to him and signaled him to roll down his window. And I tried to speak with him, but immediately I could tell that something was just off.
What do you mean?
Well, he looked extremely unkempt. I mean, his hair was all messed up, his eyes were glassy, and I could immediately smell a body odor. I also noticed some stains on his clothes, and to me, it looked like he had been in his car for days.
Then what did you do?
I asked him if I could see his license and registration, but he got a little antsy and asked me why.
Did Mr. Ray provide his license and registration?
Not at first. He tried to tell me he didn't have it, but I could see his wallet through the car.
What happened next?
At this point, I started to get a little suspicious. I explained to him that this was just a routine traffic stop and that we request license and registration from everyone who passes through.
What do you mean when you say you started to get suspicious?
Well, the thing was that I didn't think he was under the influence or intoxicated, but he was acting all squirrely.
Squirrely how?
He was restless, and he also seemed a bit nervous to me.
During this stop, did you tell Mr. Ray that you were a member of the Skelton Police Department?
I did, multiple times. But at one point, he yelled out through the window, "Are you with the CIA?"
How did you respond?
Well, I told him no, but I don't think he heard me because he just kept talking.
Did he say anything else?
Yes, he did. He said that he knew the CIA had been watching him because they thought he was a terrorist. He even said that he could hear sirens of the CIA coming to get him.
How did you respond when Mr. Ray said that he could hear sirens of the CIA coming to get him?
Well, I reassured him that there were no sirens and that I wasn't with the CIA. I even pointed to my skeleton police PD badge, and I explained again, we're just doing a routine sobriety checkpoint. And at that point, I asked him to step out of the vehicle.
Did Mr. Ray exit the vehicle when you asked?
No, he kept asking me if he could see my CIA credentials.
What did you do when he wouldn't exit his vehicle?
Once again, I showed him my police badge and I calmly told him that I work for the Skeleton Police Department, not the CIA. And at that point, he got out of his car.
Let's focus now on when the two of you were standing outside. What happened when Mr. Ray got out of his car?
His behavior suddenly changed. I mean, he was acting frantic before, but when he got out of the car, it was like he was a zombie or something.
What do you mean?
Well, he started talking in a monotone voice. He was moving really slowly, and he had a completely blank stare on his face. He also wouldn't make eye contact with me at all.
Was he talking to you in this monotone voice?
No, that was what was weird because I didn't know if he was talking to himself or to no one at all.
Was he doing anything else?
Yes, so then he did a single jumping jack. I told him to stand still, but then he did another one.
So at this point, you asked Mr. Ray to exit his car. Then he started talking in a monotone voice, and then he started doing jumping jacks. Did this behavior continue?
Well, he stopped the jumping, but then he started moving his head around uncontrollably, and he was holding his hands over his ears like a little kid or something.
What did you do once he covered his ears?
So at that point, I was able to get his arms down and cuff him.
Did Mr. Ray calm down once you cuffed him?
Not quite. He started rambling to himself in sort of a quiet but frenzied voice.
After handcuffing Mr. Ray, what did you do?
I sat Mr. Ray down on the curb and then I walked back to my squad car. And that's when my partner told me that Mr. Ray's plates had been flagged in our system.
Did you radio into dispatch that you had a person in custody who was flagged on a missing persons report?
Yes, I did. And I also radioed in that Mr. Ray was acting absolutely crazy.
Did you call for a paramedic?
No, I didn't.
Why not?
Well, when I called in to dispatch about the missing persons report, I also told them how Mr. Ray was acting completely crazy. I guess I should have, but I thought that they would have sent a paramedic along too.
Where was Mr. Ray at this point?
At this point, he was still sitting on the curb while my partner was watching him, and we had him sit there until Detective Booth arrived.
Approximately how long was it before Detective Booth arrived?
It was about 20 minutes or so.
Once he did arrive, what happened?
Detective Booth told me to escort Mr. Ray to the station and to get him set up into an interview room.
I'm sorry, hang up. Was there an objection?
Uh,
I thought I heard somebody talking. I wasn't sure.
which one?
After you told Detective Booth about Mr. Ray's behavior that night, did he request a psychiatric evaluation for Mr. Ray?
No, he didn't.
Did Detective Booth call for an EMT?
No.
Did Detective Booth even tell you to take Mr. Ray to the hospital?
No, he didn't. All he told me to do was to take him in for an interrogation.
No further questions.
All right, cross-examination.
Good afternoon, Officer Wentz. Sorry. The defendant was stopped during a routine sobriety checkpoint, correct?
Yes, he was.
You agree that you didn't stop him because he was swerving?
Yes.
He wasn't driving erratic?
No, he wasn't.
You would describe the defendant's behavior when you first approached him in the car as defiant, correct?
I mean, you could say he wasn't, I didn't describe him as defiant, but he wasn't listening to what I said, yes.
And the defendant initially refused to give you his license and registration, correct?
Yes, that's true.
And it was only after you pointed to his wallet that he gave those materials to you, correct?
Yes.
Right. So, officer, I'd like to direct your attention now to what you saw in the defendant's car. When you looked through the window of the back seat of the defendant's car with your flashlight, you saw a shovel in the back seat, correct?
Yes, I did.
It appeared like that shovel had blood on it.
I thought it,
Objection. Speculation.
May I respond?
Sure.
Your Honor, he's just testifying as to what she observed on the night of the incident.
Repeat the question.
The shovel appeared as if it had blood on it, correct?
Overruled.
So, officer, the shovel appeared as if it had blood on it.
I thought it might have been blood.
Did you think it was ketchup?
I didn't know what it was. I thought it might have been blood.
You also saw two jugs of bleach, correct?
Yes, I did.
There were multiple black garbage bags, too.
Yes.
You gave the defendant's license and registration to your partner to run?
Yes, I did.
And that's when you returned to the defendant's vehicle, correct?
Yes.
All right, so, officer, I want to talk to you now about what happened when you returned to the defendant's car. When you returned, you went to the driver's side window.
Yes, I did.
It was not until you walked the defendant's license and registration to your partner and then returned to the defendant's vehicle that he started talking about the CIA, correct?
Yep, that's correct.
When the defendant got out of the car, he said he was just trying to get his son in shape and get him to admit what he broke.
That's what he said.
He also said that he was a good father, correct?
He said a lot of things that night, yes. That was one of them.
Now, officer, you're an officer in the traffic unit,
That's correct.
and you primarily work at that specific traffic stop where you were assigned the evening of the incident, correct?
I don't know if I'd go as far to say primarily, but I work there pretty often.
So you're familiar with the spot.
Yes, I am.
And you're not a doctor?
I already said that I was a police officer.
Sorry, was there an objection?
Yes, objection relevance.
Overruled.
So you're not a doctor?
I already told you I was a police officer.
You don't have a degree in psychology?
No, I don't.
Right. Officer, I want to direct your attention to after you put the defendant in handcuffs. You learned that the defendant was a suspect in a missing persons case, correct?
Yes, I did.
And that's when you called in the case.
Yes, it was.
You didn't request an EMT?
No, I thought that they would bring one along.
But you didn't request one, correct?
No, I didn't.
And the defendant was talking about his son when he got out of the car, correct?
Again, I can't recall if he was talking about a lot of different things, but I do remember him saying something about his son.
The defendant kept saying, "He's gone. I can't believe he's gone. I'm a good father," correct?
He said a lot of different things, but that was one of them.
So you would agree with me that that was one of the things that he said during your interaction with him?
Yes, I just said that that was one of the things of the many things he said.
The defendant started crying when you told him you were going to drive him down to the station house, correct?
That was one of the times that he was crying.
But you'd agree that he started crying when you told him that, correct?
Yeah, that was one of the times, yes.
And the defendant was in the back seat of your patrol car when he stated that he messed up, correct?
Yes, that's where he was when he stated that.
And the defendant started crying as soon as he sat down in the interview room at the station house?
That was one of the other times, yes.
And he sat there with his head on the table?
Yes, he did.
He told you that he knew what he had done to his son, correct?
He never said that, or he never told me that.
The defendant said to you, though, that he didn't mean to do it.
He didn't say that to me. I told you I didn't know who he was talking to. He was saying a lot of things.
But you'd agree that you were in his presence when he was saying these statements, correct?
Yes.
And again, in your presence, he kept saying that he was a good father, correct?
Yes.
Thank you. I have no further questions.
All right, any redirect?
Briefly, Your Honor. Officer Wentz, you were asked some questions about how Mr. Ray was behaving when you encountered him during the sobriety checkpoint. When you first saw him, what did he look like?
I mean, he looked like a complete mess. His eyes were glassy, his hair was all messed up. He had an overwhelming body odor. There were stains on his clothes. It really had looked like he had been in his car for days.
Did Mr. Ray say anything out of the ordinary to you?
He asked me about the CIA multiple times, despite the fact that I kept telling him I was an officer with the Skelton Police.
No further questions.
All right, Officer Wentz, you are excused. And the defense may call their next witness.
Your Honor, at this time, we call Major Riley to the stand.
All right, Major Riley, you are sworn, you're considered under oath. And as soon as I get, I believe, Mr. Ward on screen, counsel, you may proceed.
Good afternoon. Please introduce yourself for the members of the jury.
Good afternoon. My name is Shane J. Riley.
And how are you employed?
I'm a forensic psychiatrist with a specialty in military forensic psychiatry. I've had my own forensic psychiatry practice for the past 5 years now.
Did you ever serve in the military?
Yes, I did for 7 years. I was actually appointed major in 2014.
Major, were you ever deployed?
Yes, I was deployed to Iraq. I served as a primary psychiatric consultant for over 20,000 soldiers.
Major, can you explain for the members of the jury, what is military forensic psychiatry?
Yes, of course. It's a practice area that combines psychiatry, the law, and the military. It includes all aspects of civilian psychiatry, but also psychiatry of military personnel.
And Major, why are you here today?
I was contacted by Timothy Ray's attorney to review his case and form an opinion as to whether or not Mr. Ray was suffering from any mental disorder on October 17, 2018.
Okay, before we get into that opinion, Major, I just want the jury to get to know a little bit more about you. So how did you become a military forensic psychiatrist?
I first obtained my bachelor's degree in biology from the University of Notre Dame in 1993. I then received my medical degree from the Uniformed Services University of the Health Sciences, F. Edward Herbert School of Medicine in 1997, where I actually graduated fourth in my class.
So Major, after you received your medical degree, did you go on to do some sort of residency or fellowship?
Yes, I completed a 4-year psychiatry residency in 2001 and the 1-year forensic psychiatry fellowship in 2002 at the National Capital Consortium Psychiatry Residency Program at the Walter Reed National Military Medical Center, or for short, Walter Reed, where I later worked once I returned from Iraq in 2006.
So once you returned from Iraq, what work were you doing for Walter Reed then?
I worked as a managing clinical psychiatrist for 5 years, in which I managed the hospital's psychiatric inpatient unit. I treated hundreds of military personnel suffering from a wide variety of mental health disorders, including schizophrenia. I then worked as a deputy director for Walter Reed for an additional 5 years, providing psychiatric evaluations.
So you mentioned that you treated patients with schizophrenia, but have you ever published any articles about schizophrenia before?
Yes, I've actually written 2 articles relating to schizophrenia.
And Major, how long did you spend reviewing materials for and forming opinions in this case?
19 hours.
And Major, what materials did you review for this case?
I reviewed my own notes from my treatment of Mr. Ray in 2010. I conducted a second interview of Mr. Ray in 2019. I also interviewed his father, his ex-wife, and his employer. I examined all the materials sent by his attorneys, including the exhibits in this case and the police reports.
And what did you do after you reviewed those materials?
I conducted a psychological evaluation. I interviewed Mr. Ray's friends and family and compared his actions with a DSM-5 to determine if he met the criteria to be diagnosed with any specific illness.
And Major, are these the type of materials that are typically relied upon by experts in the field of military forensic psychiatry?
Yes, they are.
Did you rely on these materials in forming your conclusions and opinions today?
Yes, I did.
And Major, do you hold your opinions to a reasonable degree of medical certainty in the field of military forensic psychiatry?
Yes, I do.
If at any point in time you're unable to hold your opinions to that reasonable degree of medical certainty, will you let us know?
Of course.
Now, Major, did you form an opinion about whether Mr. Ray was suffering from a mental disorder on October 17th, 2018?
Yes, Mr. Ray was suffering from schizophrenia on that day.
Can you just explain for the members of the jury, what does it mean to suffer from schizophrenia?
Of course. Schizophrenia is a brain disorder in which a person can experience positive and negative symptoms associated with the illness. The various symptoms are outlined very specifically in the DSM-5.
Major, do you have any materials that would help you today?
Yes.
Constructively turning everyone's attention to what has been marked as Exhibit 32 for demonstrative purposes only. Major Riley, do you recognize?
Yes, I do.
And what is it?
This is an informative PowerPoint Prezi presentation breaking down the decline in Mr. Ray's mental health, including the schizophrenic signs he exhibited leading up to the night in question.
And do these materials accurately reflect the symptoms of schizophrenia?
Yes.
And will this demonstrative help you explain your testimony to the members of the jury today?
Yes, it will.
Your Honor, permission to publish Exhibit 32 Your Honor, permission to move Exhibit 32 into evidence first for demonstrative purposes only.
Any objection?
Yes, Your Honor. The expert witness hasn't testified to each line of the contents of the demonstrative. So none of that is already in evidence or in the record. Publishing it prematurely would be a problem.
Your Honor, I'm asking to first move it into evidence, and then I will publish the lines as Major Riley states each section.
With that,
who prepared this PowerPoint?
I apologize.
I'm sorry, who prepared this PowerPoint?
Major Riley did. She testified to that previously.
Okay, so these are her words, not yours.
Yes, Your Honor.
Her opinions, not yours.
Yes, Your Honor.
All right. I will receive it as a demonstrative, meaning it will not go back into the jury room with the jury. However, you may use it during Major Riley's presentation as well as during closing arguments if you wish.
And Your Honor, at this point, may I additionally publish Exhibit 32 on the screen as we move throughout Major Riley's testimony? Thank you, Your Honor. Major Riley, you said that you conducted an evaluation of Mr. Ray. When did you conduct that evaluation?
I conducted that evaluation on September 8th, 2019.
And during that evaluation, did you come to learn, what are the positive symptoms? Sorry about that, Major. What are the positive symptoms of schizophrenia?
The positive symptoms of schizophrenia can basically be summarized by saying that there's a difficulty discerning reality from hallucinations and delusions.
And how about the negative symptoms?
A person suffering from schizophrenia may experience a loss of interest. They may experience social phobias, impaired ability to manage emotions, a lack of hygiene or care for themselves, and change in sleep patterns.
So, Major, what causes schizophrenia?
There are actually several contributing factors, including a person's genetics and any childhood trauma that they have experienced.
Now, you mentioned that you conducted an evaluation of Mr. Ray. During that evaluation, did you come to find that Mr. Ray was experiencing any of these positive symptoms?
Yes, actually, he'd been exhibiting multiple symptoms over a number of years. First, he was having auditory hallucinations at 10 years old, which is a common symptom of schizophrenia.
Major, did he only hear these voices when he was 10?
No, Mr. Ray stated that creepy male voices returned in the months leading up to October 17, 2018. And also additionally on the day, on the 17th, those voices told him to kill his son.
Major, is it typical for schizophrenic patients to hear voices that urge them to commit violence?
Yes, unfortunately, it's quite common. A person suffering from schizophrenia hears voices that don't exist, but to them, the voices are very real and very controlling. Often the voices are instructing them to do something. Often people suffering from schizophrenia believe that the only way to quiet the voices is to follow their commands.
Major, follow the commands even if they urge them to commit violence?
Yes, in some cases that happens because a schizophrenic person may feel like their will is overborne and that they must follow the commands.
And in your expert opinion, can a schizophrenic person just ignore these voices?
It would be very difficult because it's as if a person is constantly shouting in your ear. It would be pretty hard to ignore.
Major, did you come to find that Mr. Ray was suffering from any other positive symptoms of schizophrenia?
Yes, he had visual hallucinations in 2017 and 2018. He also experienced a series of paranoid delusions about his wife and son cutting him up with a knife and the CIA following him.
Okay, Major, I want to turn to negative symptoms now. Did you come to find that Mr. Ray was suffering from any negative symptoms of schizophrenia?
Well, Mr. Ray had angry outbursts, once at work, once during his examination by Dr. DiGiuseppe, and once in my office. Additionally, I also learned from his employer, Nia Jacobs, that Mr. Ray was crying in his cubicle a few times alone. So sudden changes in emotions like these are considered a negative symptom of schizophrenia. They're actually called emotional lability.
Okay, and Major, were there any other negative symptoms that you found Mr. Ray was experiencing?
Yes, actually, after speaking with Jessica Ray, his ex-wife, she stated that Tim had mood swings where he would feel okay 1 minute and then be crying the next. He became more and more isolated over the years. He would lock himself in the bathroom for hours at a time. He would go for more than a week without showering. These behaviors demonstrate an impairment in function and also suggest a lack of interest, which are negative symptoms of schizophrenia.
Major, was there anything else that you learned about Mr. Ray from those interviews that you conducted?
Yes, I also learned from Abe Ray, Tim's father, Mr. Ray's father, that Mr. Ray's mother neglected him as a child. His mother would often refuse to feed him and force him to take cold baths. Also, his mother was institutionalized for an undiagnosed mental illness. So in this case, both genetics and childhood trauma can contribute to schizophrenia.
Now, Major, you mentioned that you evaluated Mr. Ray on September 8th of 2019. Did he experience any symptoms of schizophrenia while he was in your office?
Well, yes, actually. Towards the end of the interview, Mr. Ray started sweating profusely and accused me of being a government agent who was out to get him. He accused me of having a camera in the microwave in my office. There was also a point where he started crying uncontrollably.
Major, you are aware of the interrogation that Detective Booth conducted on Mr. Ray and the moments leading up to it.
Yes, I am.
And was Mr. Ray exhibiting any symptoms of schizophrenia during that time?
Yes, he was.
And are those symptoms consistent with somebody who needs a psychological evaluation?
Yes.
Major, did Mr. Ray receive a psychological evaluation before being interrogated by Detective Booth?
No, he did not.
No further questions on direct, Your Honor.
All right, cross-examination.
Yes, Your Honor, one moment. Good afternoon, Major Riley.
Good afternoon.
Major Riley, I'd like to talk to you a little bit about some testimony in a 2016 criminal case concerning an assault that you did. Now, Major Riley, this isn't the first time you're testifying in a criminal case, is it?
No, it's not.
You testified in an unrelated criminal case in 2016, is that true?
Objection, Your Honor. Relevance?
Response.
Your Honor, this line of questioning is going to elicit statements about diagnosing a defendant with schizophrenia that the expert witness made in 2016 under oath. The state is entitled to cross-examine the witness's prior statements.
Well, you're allowed to cross-examine the prior statements if they're relevant. Why are they relevant?
They're relevant because in the 2016 case, Your Honor, the Major Riley was also testifying for the defense. It was also a defense in which an insanity defense was being offered. And it was also a case in which the defendant was diagnosed with schizophrenia as part of that insanity defense.
Do you wish to be heard any further?
Your Honor, if I may make an offer of proof.
Right. I'm asking you if you want to be heard any further. So if
Yes.
whatever it is you have to say, go ahead.
Yes, Your Honor. If I may be heard outside the presence of the jury, I do not believe that Major Riley or that the prosecution will be able to elicit testimony from Major Riley regarding schizophrenia in any past patient. Additionally, I don't see how previous diagnosis of schizophrenia of somebody completely irrelevant to this case is relevant at all.
Your Honor, if I may.
Go ahead.
This line of questioning goes directly to the credibility of the expert witness.
I'm going to sustain the objection at this point. I don't know where it is you're going with this. So at this point, I'm going to sustain it.
Yes, Your Honor. Major Riley, you're aware that the defendant on trial today was treated by Dr. D. Giuseppe.
Yes, I am.
You're aware that the defendant has also been evaluated by Dr. Narasimhan.
Yes.
Now, in 2010, you yourself evaluated the defendant's mental health. Isn't that true?
Yes, it is.
But you didn't diagnose the defendant with schizophrenia in 2010, did you?
No, I didn't. At the time, he was not exhibiting the appropriate symptoms for schizophrenia to my evaluation directly.
Well, the question I asked you was a little different than the one you answered, Major Riley. You didn't diagnose the defendant with schizophrenia in 2010. Is that a yes?
I did not diagnose him with schizophrenia.
Now, Dr. G. Giuseppe didn't diagnose the defendant with schizophrenia in 2017.
No, that is outside the realm of her practice. She did not.
Okay, but Dr. Narasimhan didn't diagnose the defendant with schizophrenia in 2019 either.
No.
So, to be clear, the defendant has never been clinically diagnosed with schizophrenia.
No, he hasn't.
In fact, out of all the doctors that have seen, treated, and evaluated the defendant, the first one to conclude that he has schizophrenia is you.
That is correct.
Now, Major Riley, you're being paid in this case.
Yes.
You're being paid by the defense.
Yes.
In fact, you gave this defendant a discount from your normal rate. Is that true?
I provided a lower charge because I know Mr. Ray from previously, and it took a lot less time for me to go over the files.
Right. Major Riley, I'd like to talk to you now about malingering. And just so the jury understands, we mean faking or pretending symptoms for an insanity defense, correct? Now, Major Riley, we agree that the more serious the crime, the higher the likelihood of malingering.
Yes.
Now, it's your opinion that a murder charge is the most serious crime one can commit.
Yes.
Now, during your interview with the defendant, when you confronted him with an inconsistency in his story, he had what you described on direct as an angry outburst. Is that true?
That is very true because it was a very stressful time for him. I'm not surprised at all that he had that outburst.
Major Riley, when the severity of someone's symptoms increase in the face of imminent culpability, the likelihood of malingering also increases.
Yes.
Major Riley, you'd admit there's a chance that this defendant is malingering.
There's always a chance that anyone under psychiatric care or diagnosed with a psychiatric illness is malingering.
And Major Riley, as you sit here today, you cannot tell this jury with certainty that Timothy Ray was not malingering.
No, I can't, but it is, in my clinical opinion, after years of practice, that he is suffering from schizophrenia.
So that's a no.
No.
Nothing further, Your Honor.
All right, any redirect?
Yes, Your Honor. You previously mentioned that you saw Mr. Ray that you had diagnosed him with anxiety and depression. Are anxiety and depression symptoms of schizophrenia?
They definitely can be. They can lead to worsening of schizophrenia, and they can also precede schizophrenia.
Additionally, you were asked whether or not the prison doctor assessed Mr. Ray with schizophrenia, and you responded, had not.
That is correct.
Did that prison doctor prescribe Seroquel, which is an antipsychotic drug, to the defendant?
Yes.
And does that drug treat schizophrenia?
Yes, it does.
Thank you, Your Honor. Nothing further.
All right. Does the defense have any further witnesses or evidence?
No, Your Honor. No further witnesses or evidence.
Your Honor, at this time, the defense renews our earlier motion for judgment of acquittal.
Oh, hang on. You got to rest first. Does the defense rest?
Yes, Your Honor.
Okay. All right. So then let's go outside the presence of the jury. Do you have any additional arguments, or is this based on the same argument that you previously made?
The same argument we previously made.
All right. Then in that case, I will make the same ruling as I previously did. Are the timekeepers prepared to give us a time check at this point, or do you need a couple of minutes?
Your Honor,
I haven't checked with Gina yet, but I do have.
Okay. Then let's do this. Do you all need a break before closing arguments, or are you prepared to go directly into closing arguments once you find out how much time you have left?
I'm prepared, Your Honor.
I as well, Your Honor.
Okay. Then as soon as our timekeepers have had a chance to consult with one another, then we will go directly into closing arguments.
Your Honor, may I briefly switch to my other camera?
Yeah, I think that would be a great use of the time right now.
Thank you, Your Honor.
Your Honor, the state has 16 minutes and 46 seconds left, and the defense has 11 minutes and 53 seconds left.
All right. Then we will now hear closing arguments from each party. Everyone should switch back to speaker view. All right. Looks like our jurors are good to go. And we will go ahead and begin the closing arguments with the prosecution.
Child deserves to feel safe in his father's arms. Child deserves to grow up. Well, you've heard a lot today about the defendant, Remember the little boy whose body was left in a shallow grave? A boy with blonde hair and green eyes, liked to play with Legos and eat Frosted Flakes. The boy that was strangled to death by this defendant, and whose body the defendant put in a garbage bag in a shallow grave in the woods of Brandywine State Park. The defendant killed Nathan in a fit of rage, but rage does not equal insanity. As the prosecution, we have the burden in proving this case to you today, and we have proven each and every element of this case beyond a reasonable doubt. We had to prove to you that that Timothy Ray killed Nathan Ray with malice aforethought. That means intentionally and with premeditation. In order to find that a person kills with premeditation, you have to find that he decided to kill after a period of reflection, no matter how brief. Premeditation means that the defendant thought about it first, even if for a matter of seconds, and then decided to do it anyway. Let's first talk about how the defendant killed Nathan. Remember, we know every gruesome detail of this because the defendant confessed to Detective Booth. And Detective Booth ensured that the defendant knew that he was waiving his Miranda rights. He took time to make sure he understood each and every part of that form. So the defendant told Detective Booth that on the morning that he murdered Nathan, Nathan spilled a cup of juice on the defendant's laptop. The defendant was enraged. He walked back to Nathan's bedroom, belt in hand, and raised it above his head and hit Nathan with it over and over again. Nathan screamed in fear and in pain. He cried out for his mother. The defendant wanted to stop that screaming, stop that crying for good. But he almost didn't do it. He sat on his bed, thought about just letting it go. That was the moment of premeditation. The defendant thought about it first and made up his mind. Then placed the belt around little Nathan's neck and pulled it tighter and tighter till Nathan stopped screaming, stopped moving, and stopped breathing. Because of the overwhelming evidence that the defendant killed Nathan Ray and that he murdered him, the defense has tried to convince you that the defendant should not be held accountable for his actions because of an alleged bout of insanity. To prevail, the defense has to prove that at the time of the murder, the defendant was suffering from a severe mental disease or defect, meaning that the defendant did not know or did not understand the physical nature and consequences of what he was doing. They had to prove this to you by clear and convincing evidence. They have not met this burden today for 3 reasons. First, the defendant did not show any symptoms of schizophrenia. Second, the defendant understood what he did was wrong and even tried to cover it up. And third, any symptoms that the defendant allegedly did show can be attributed to him malingering or faking those symptoms as a way to try to get away with murder. Let's first talk about the defendant's lack of symptoms. You've learned about the defendant's background, about his upbringing, his work history, and his marriage. You also learned that aside from a few bad days that we all have, this history is uneventful. Dr. LaGreca explains that nothing in the defendant's history is consistent with a diagnosis of schizophrenia. You'll learn that schizophrenics do poorly in school, but The defendant has a bachelor's degree in computer sciences from Skelton University and even graduated summa cum laude. You also learned that schizophrenics have difficulties maintaining employment and issues at work. But you'll learn that the defendant was never formally disciplined at work, and his boss even referred to him as a fantastic employee. As for his medical history, the defendant has never had a history of schizophrenia. Even the defendant's expert had to admit that the most important factor in determining whether someone is schizophrenic is whether he's previously diagnosed. In 32 years, the first and only diagnosis that the defendant was a schizophrenic came from the doctor that the defendant paid to testify at his murder trial. 32 years, not a single diagnosis, not even a single schizophrenic episode. That is because the defendant is not schizophrenic. Second reason why the defense has not met their burden today is because the defendant tried to cover up and get away with the crime. Meaning, he understood his actions and knew what he did was wrong. Will bleach destroy a body? How to get rid of a body? Countries that don't extradite for murder charges. These are not the searches of someone who does not understand right from wrong. They are plans A, B, and C. Plan A, to destroy Nathan's body with bleach. Plan B, to get rid of Nathan's body by burying it in the woods of Brandywine State Park. Plan C, to flee the country. When plans A, B, and C all failed, when the defendant got caught, the defendant turned to plan D, desperation. Act crazy as a last-ditch effort to try to get away with murder. And that is the third reason why the defense has not met its burden today. Because you learned that the defendant was just faking. Both experts spoke at great length about malingering or faking symptoms. And both experts agree that in a murder case, the likelihood of malingering is significantly higher. That makes sense. The higher the stakes, the more likely that someone's going to try to get away with it. And the defendant, he knew what was at stake. He said so to Major Riley, that he was afraid about going to jail for what he had done. The defendant had every reason to fake insanity, and that is just what he did. Try to meet their burden, the defense brought to you their own expert, Major Riley, to testify before you. Major Riley is the first medical professional to ever diagnose the defendant with anything more serious than general anxiety disorder. And as you learned, Major Riley actually interviewed the defendant back in 2010. And at that time, Major Riley didn't see any signs of schizophrenia, just like Dr. LaGreca, Dr. DiGiuseppe, Dr. Narasimhan. The defendant, Major Riley did not think that the defendant was a schizophrenic. So what changed? Well, what changed is that the defendant wrote Major Riley a check for a diagnosis that he hoped would get him off. The defense also brought to you Police Officer Wentz, a witness with no medical knowledge or expertise, and who had never met the defendant before that sobriety checkpoint on the evening that the defendant was arrested. Rather than calling someone, anyone in the defendant's life, they called a cop who deserved the defendant once and only after he had already killed Nathan and already had every reason to fake his symptoms. They didn't call someone who lived with the defendant, who worked with the defendant, who knew the defendant well. The reason why they didn't call any of those people is because the defendant never showed any symptoms of schizophrenia. The defendant is not a schizophrenic. He's just an enraged person who lost his temper and did the unthinkable. Remember who the defendant took from this world. Smiling 6-year-old boy with his whole life ahead of him. Boy, blonde hair and green eyes, who liked to play with Legos and eat Frosted Flakes. A boy who deserved to see his 7th birthday, but never will. Don't let the defendant get away with taking Nathan's life. Find the defendant guilty of murder in the 1st degree. Thank you.
All right, thank you. Defense, do you have a closing argument?
Yes, Your Honor. May it please the court, counsel, ladies and gentlemen of the jury, Timothy Ray is sick. He has a disease, not of the body, but of the mind. When the state brings charges, they have to prove it. They have to prove that Timothy Ray intentionally killed Nathan, that he premeditated and deliberated. But they haven't done that today. They have to prove beyond a reasonable doubt. But ladies and gentlemen, their case is full of speculation, full of doubt. The only confession that you heard about today was a transcript, not a recording. Booth didn't want you to see how Tim was acting that night. You can't see Timothy's slow movements or blank stares. You can't hear how Timothy was asking questions about the CIA. You can't hear how Booth was feeding into Mr. Ray's delusions or how he called him a piece of shit. Don't ignore the fact that there's not a single piece of physical evidence connecting Mr. Ray to the crime. No DNA, no fingerprints, nothing. But let's say you're buying the story that the state is trying to sell you. Then you get to the next step in your analysis. On behalf of Mr. Ray, we asserted the affirmative defense of insanity. It was our burden to prove to you by clear and convincing evidence, meaning highly and substantially more likely to be true than untrue, that Mr. Ray suffered from a severe mental disease or defect at the time of the act, and that as a result of that severe mental disease or defect, he was unable to appreciate the nature of what he was doing, or that he was unable to appreciate the wrongfulness of his acts, or that he was doing something wrong. And that's why Major Riley's here today, to tell you, members of the jury, that what Mr. Ray did that morning wasn't because he wanted to do it. It's because he's sick. He has a disease. Members of the jury, we know Mr. Ray has schizophrenia. LaGreca even admitted that Mr. Ray reported delusions. He was hearing voices. And Major Riley, she told you about the delusions. Mr. Ray thought that his own wife and son were going to chop him up with a knife. Things got so bad that Mr. Ray was locking himself inside of the bathroom for hours at a time, refusing to come out. Members of the jury, we know now that Mr. Ray didn't mean to kill Nathan. He has a disease. And that disease took his thoughts away from him, took his actions away from him, took his son. Mr. Ray's disease prevented him from understanding just exactly what he was doing. And because of that, you have to return the only verdict that is supported by the evidence and required by the law. Find Timothy Ray not guilty.
All right. Does the prosecution have a rebuttal argument?
Yes, Your Honor, just switching to the second camera.
All right.
Defense just argued that there is no physical evidence tying the defendant to the crime. So if the defense is arguing that the defendant didn't kill his son, why are they putting on an insanity defense? I'll tell you why. Because the defendant knows that the defendant murdered his son. Defense wants you to believe that the defendant could not understand the nature or wrongfulness of his actions when he murdered Nathan. Yet there he is, sitting in his house, typing precise and well thought out search terms into his phone, with his son's lifeless body laying in the next room. How to get rid of a body? Will bleach destroy a body? Countries that don't extradite for murder charges. Murder. Extradition. These are the words and thoughts of a lucid and calculating person. If he truly was not conscious of his actions, or if he truly did not understand what he did was wrong, once his bout of alleged insanity was over, he would have called the police, a doctor, his ex-wife, anybody, and tell them something happened to Nathan. Instead, with his son's dead body still in his home, he is desperately trying to figure out a way to escape accountability for what he had done. He then gets a shovel and garbage bags and tries to dispose of Nathan's body. Remember these search terms. Remember the photographs of Nathan's body thrown in the woods of Brandywine State Park and buried in dirt in a garbage bag. Remember Nathan, a smiling 6-year-old boy who deserved to see his 7th birthday. Don't let the defendant get away with murdering 6-year-old Nathan. Find the defendant guilty of murder in the 1st degree. Thank you.
All right, everyone. Thank you very much. You can give me one moment. Okay, we need the judges to please complete their ballots. I'm going to ask everyone to stay on until all of our judges have submitted their ballots, and then we will do some brief comments. And I'm sorry, just let me clarify for the judges. Once you've submitted your ballot, let me know, and I will be able to check to make sure that your ballots have gone through. Okay. Yeah, Miss Finkelstein, yours did not go through yet. So yeah, I think you're best off in resubmitting. Okay, so good news, we have our ballots in now. So if I can get everyone to turn their cameras on. And we have a little bit of time for comments from our from the attorneys. And because we've got so many judges, we want to make sure that we've got everybody, or we give everybody an opportunity to get prepared for their next trials. We're going to ask each judge to limit themselves to one comment, either their favorite moment from the trial or one suggestion for one of the competitors. Right, and so let's go ahead and start with the first juror on my screen, Ms. Finkelstein, or Finkelstein. I'm always unsure as to which way people pronounce it. So I will let you introduce yourself.
Oh, sure. No preference. I'm Veronica Finkelstein. I have been coaching mock trial at the high school, collegiate, and law school level for over a decade and doing moot court as well. This is my first time judging on Zoom. So I am going to mostly give you one Zoom specific suggestion. And my one Zoom specific suggestion is, I just told you I've done these for a decade. This one felt much longer than all of the other ones. And I think it's because we're on Zoom. So to the extent that there are pretrial rulings and objections that don't really advance your case, this score sheet does not give me a way to reward or penalize you in any specific way for your demonstration of knowledge of the rules of evidence or case theory in a way that links in to the objections and the pretrial arguments. And everything feels longer on Zoom. So my suggestion is keep the good directs and crosses, keep the good openings and closings, cut way, way, way down on the objections, and especially these arguments at the beginning of the trial. It did not seem to me to advance the ball of your case theory. You seemed prepared to go forward regardless of the rulings. And that was the place where I couldn't reward you even if I thought you did know the rules of evidence. And a lot of it just seemed to be a first line shell of something that you were prepared to say, but then when you were pressed to back it up, it didn't particularly seem like you had thought through why it mattered or had a second line reasoning. So I would just diminish that. That's my opinion for everybody all around, not just you guys, but for everybody in this competition. On Zoom, that is not earning you any particular points, I don't think.
All right, thank you very much. And next, Mr. Weingarten.
Unmute. Hi, my name's Mark Weingarten. I've been a lawyer for 45 years. I've published over 75 articles on trial tactics, and I've lectured over 100 times throughout the United States and Europe on persuasion and trial of cases. If it were not for COVID, I would be a visiting professor at Nicholas Copernicus University in Poland right now, but I can't go over there. So I enjoyed listening to all of you. You did a great job. It's difficult to limit my comments to just one or two. I will say, from a general nature, I was impressed, at least from this side of the camera, that none of you seem to have to refer to notes. Whether you're looking at a monitor and I couldn't tell, that's a function of Zoom, I guess. But that, I was impressed by that. I think all of you took advantage of when the judge overruled objections. You made sure that you plowed right into the question again so that the fact finder, the jury, knew that you had won that one and you were going to go in and get what you want because the judge said it was okay. I have individual comments for all of you, but we don't have time for me to go through it. But I thought that it was an impressive. It was very difficult to score because you all were so well prepared and did so well. Congratulations to all of you.
Excellent. Thank you very much. And last but not least, Ms. Padilla.
Good afternoon, everyone. I have been both a litigator in Chancery as well as Law Division in the state of New Jersey, but I've also done a great deal of legislative work as an attorney. I provide that to the students only by way of introducing the concept of nonverbal communication. as attorneys before a jury, it's not only the words that come out of your mouth, throughout your professional career. The four of you are amazing. I would be pleased to work with any of you. A couple of contributions that I would like to offer. Ms. Yanez, you have a wonderful, slow, calm pattern of presentation that is very effective. Ms. Pasculo, you have extremely effective body movements that are consistent with your message. So you have a lot of consistency there, very, very effective. It's good for the rest of your presentation. Ms. Gavazi, I also thought you were also very effective. The only advice I would have, and maybe it's just because this is a first time event, it seems you seemed prematurely almost too solicitous of the court. You were asking the court, would you like me to blank, even before there was a reason for the court to do something. And you know, when you would say, you know, may I blank, it would almost seem like it's a bit too premature. So maybe just calm down a little bit and get your sense of timing from the court. And Mr. Ward, extremely effective presentation. Again, on the nonverbal, the only one thing I would have to offer, and I have to control this myself, is eyebrow movements at times seemed a little bit distracting. And so those are all things you could control. Really great for you to hear about our suggestions at this level. You're all rock stars. I would love to work with you at any point. Thank you for the opportunity.
All right, everyone. Thank you all very much. First round for the day. Signing off at this point. Good luck to everyone. You can't hear me?
Your Honor, we can't hear you.
Can you hear me now? That was a test. I wanted to make sure that you were all paying attention, and all of you just kind of sat there like, except for Ms. Padilla, who was like, what I was saying is thank you all very much for a good round. Good luck to everyone in the subsequent rounds, and definitely thank you to our jurors for taking time out of your Friday afternoon / early evening to help us out with the tournament. All right, everyone. I'll be ending the Zoom room now, and good luck and to everyone for tomorrow.